The quote before we begin this chapter: wake up with some determination that you have to do something, and when you go to bed, be satisfied that you have done your studies. Take chances. In the end, we regret only the chances we didn't take. Let's cover a small chapter. This is for a change not on the magistrate but on the police. Chapter 11: Preventive Action of the Police. It is covered under section 149 to section 153. The first point is police to prevent cognizable offences. The second point, information of design to commit cognizable offences. The third point is arrest to prevent the commission of cognizable offences. The fourth point, prevention of injury to public property. And the fifth and the last one, inspection of weights and measures. First point of chapter 11, police to prevent cognizable offences as per the provision of section 149. Section 149 says every police officer may interpose. Interpose means to block, intercept, intervene, or to mediate. This is what he is going to do. But for what? For preventing, and shall to the best of his ability prevent the commission of any cognizable offense. So he is going to prevent any offense which is considered as cognizable. Now don't tell me you don't know what is cognizable offenses. Anyway, we can revise it. Section 2 subsection C of Criminal Procedure Code says cognizable offences means an offence for which, and cognizable case means a case in which a police officer may, in accordance with the first schedule or scheduled under any other law for the time being in force, arrest without warrant. Second point of the chapter, preventive action of the police, is information of design to commit cognizable offences as per the provision of section 150. Section 150 says every police officer receiving information of a design to commit any cognizable offence, what he is going to do, he shall communicate such information to police officer to whom he is subordinate and to any other officer whose duty is to prevent or take cognizance of the commission of any such offences. This means that every police officer is duty bound when he gets some informative things, a design that something is going to happen and that is going to be a cognizable offense. He will be informing it to his senior, to whom his subordinate means he is going to inform to his immediate senior, or he will inform directly to those police officer whose duty is to prevent such commission of cognizable offense. Third point of preventive action of the police is arrest to prevent the commission of cognizable offences as per the provision of section 151. Subsection 1 of section 151 says a police officer knowing of a design to commit any cognizable offence. In section 150, we have read that a police officer will be informing his senior, will be informing to the officer who is in charge of taking such offences. Over here in section 151, subsection 1, we are covering that he may arrest without orders from the magistrate and without a warrant the person so designing, if it appears to such officer that the commission of the offence cannot be otherwise prevented. And subsection 2 of section 151 says no person arrested under subsection 1 shall be detained in custody for a period exceeding 24 hours from the time of his arrest. So the time limit is given 24 hours, but there is a condition: unless his further detention is required or authorized under any other provision of this code or any other law for the time being in force. So, one important thing that we learn over here is a person who is designing a cognizable offense will be arrested under section 151, but not for more than 24 hours. Fourth point of the chapter preventive action of the police is prevention of injury to public property as per the provision of section 152. Now, section 152 says a police officer may, of his own authority, interpose to prevent any injury attempted to be committed in his view to any public property, movable or immovable, or the removal or injury of any public landmark or buoy, that is to indicate the danger, a point which sometimes we mark as red, or other mark used for navigation. These are all the duties of a police officer which he is going to do to prevent of injury to public property, as the section 152 itself says. Now we come to the last point, fifth point of the chapter preventive action of the police, inspection of weights and measures as per the provision of section 153. This is used, the weigh and measures are basically used by businessmen or shopkeepers. Subsection 1 of section 153 says any officer in charge of a police station may, without a warrant, enter any place within the limit of such station, this is police station actually, for the purposes of inspecting or searching for any weights or measures or instruments for weighing used or kept therein, whenever he has a reason to believe that there are in such place any weights, measures, or instruments for weighing which are false. I hope you don't need any explanation in this, that he can enter any shop, any place, and that should be within the limits of his police station, and without any warrant he can check the weighing machines or the instruments. However, subsection 2 of section 153 says if he finds in such place any weigh measures or instruments for weighing which are false, what he is going to do? He may seize the same and shall forthwith give information of such seizure to a magistrate having jurisdiction. So he has the power to take such false things in his custody. Subsection 1 says he can enter any place to check such measuring machines, weight, etc. Subsection 2 says he can take the seizure, he can take it into his custody and inform the same to the judicial magistrate. That's it. With this, we come to the end of this chapter, and don't forget to give love to the kids and respect to the elders. Trust me, it costs nothing.